Wait, wait, wait. Now, sir. For delivery of order, item 1, WPC 917/2026, Savera Begum versus the Union of India.
Two issues. First is with regard to the reference made by the ERO. That aspect we have dealt with. The interchange of the records that we have dealt with. And accordingly, it has been held that the petitioner would participate in the proceedings of the FT case number 7 of 2024. Accordingly, this writ petition fails. Item number? You wanted adjournment in the matter. When? Okay. Both as represented on the prayer made by Learned Counsel for the petitioner. Matter is adjourned based on 19th. Yes. Nine, you'll have to wait. It's 2019 matter.
9 or 19?
9 is 2019 matter. Please wait. We'll consider that. No, that's okay, but we'll consider only when the matter is reached. Not now, because this 2019 matter, we have some urgency in the matter. Without looking at the records, we are not adjourning old matters. Two and four, same thing. Same thing. We'll unless we see the records, we are not adjourning it. Renew the prayer when the matter is called. 2019 and 20 matters, we are not adjourning without looking at the records. '29 and 30. 31. Both sides are represented on the prayer made by Mr. H. Alia and the standing counsel for the finance department. Time is allowed to file. Time take on the matter is adjourned today so as to enable the finance department to file affidavit in the matter. Next paragraph. How much time? Okay, give a date after 2 weeks. List on so and so. The affidavit shall be filed at least 2 days prior to the next date of listing.
1st of April.
40. Okay. Okay, both sides are represented on the prayer made by learned counsel to the applicant. The matter is adjourned today. List after a week. Okay. In 2019 matter, we are not adjourning without looking at the records. Whatever be, if you are not there, you are not there. Why will you take an adjournment then? No. For that, you don't have to mention. Once your brief is taken away, then you have no locus to make a mention. You're not his, no longer his representative. That's why. For the item to be called. Then, again, 2019 matter, please wait. At 10, refer to 7.
For motion, item 1, WPC 3678/19.
Both sides are represented. The prayer made by learned counsel for the petitioner, the matter is adjourned today. List on you, complete after 2 weeks. First of April.
Item 2, WPC 4200/19.
And so John today, list on and so. As this is a whole matter, no prayer for adjournment shall be considered on the next date of listing. Please date. You first.
Item 3, for motion.
Page number. Please put on your speaker. I'm not hearing you properly. Put on your speaker.
Lordship, page 45 is the impugned judgment, Lordship,
Yes.
order of the tribunal. What judgment may I read, Lordship?
After 66, you are in 1997. happened in
My
between?
brutalism, 66, my parents' brutalist, and 1970, I photocopy produce, that is answer 5.
31 years.
Lordship,
What happened during these 31 years? 66, after 66, 97.
my parents expired, Lordship, in 91. Father expired 1974, 74. The mother expired 1986. I obtained only these two their documents, and I searched my brutal list in the my name appeared in the brutal list 1990, but I could not get it. Prior to that, I also aware of that but could not remember which brutal list. But I produced the brutal list of 1997 with my name, Lordship, and I also produced the sale deed of my name, Lordship, that is 1975. Annex 4, that is exhibited as an Annex 4, Lordship. And final quotidian of my father also, Lordships, that is 28 to 1967. And here tribunal, Lordships, only consider the exhibit 1 and 6, but exhibit 2, 3, 4 and 5 not considered. Even the evidence of OPW2, Lordships, discarded totally. There is no sustainable law, Lordship. You have to consider everything, Lordship. Only two documents considered, Lordship Tribunal. Your Lordship, finding is at page, start from page 45, Lordship, bottom may I read. OP in his written evidence stated that his name is Binoy Das, aged about 72 years, and he was born at village Basudev Nagar, PS Patargandhi, Karimganj, and his parents' name are late Bipin Ram Das and late Monobala Das, and grandfather's name is late Surjaram Das. OP also stated that his parents' name had been enlisted in the brutal list of 1966 under 7 South Karimganj LA constituency, part so and so so and so. So exhibit 1 is a certified copy of the said brutal list. OP also stated that his name enlisted in the brutal list of 1997 under LSC for South Karimganj along with his wife and daughter. Exhibit 2 is a certified copy of the said brutal list. OP also stated that his name enlisted in the brutal list of 2005 under LSC of South Karimganj along with his wife and daughter. Exhibit 3 is the certified copy of the said brutal list. OP also stated that he paid house tax for residing at village Basudev Nagar under Dalsara Gaon Panchayat. Exhibit 4 is the said tax receipt of dated 27/1/2003. OP also stated that he has land and property at village Basudev Nagar in his name, and to show that he has submitted one Xerox copy of registered deed dated 7 to 1975 and support is a photocopy of the said deed. OP also stated that he has submitted one photocopy of the voter list 1970, where his parents' name recorded, and Annex 5 is a photocopy of the said voter list. OP also, in his additional examination in chief, stated that he has voter identity card in his name by number so and so. Exhibit 5 is the photocopy of the said card, proved in original. OP also stated that his father's name is recorded in the land final Khotian number 3 of Moja so and so so and so. PS District Karimganj, Exhibit 6, the said Khotian. In the written evidence of OPW2 stated that he know the OP since OP's childhood and also know the OP's parents since prior to the year 1966. OPW2 also stated that OP has been residing in the village Vasudevnagar continuously and uninterruptedly since prior to the year 1966. OPW2 also stated that he has a voter ID card in his name by number of photo. Exhibit 7 is the photocopy of the said card to be original. On perusal of the above evidence, now question arises whether voter list of 1960 Exhibit 1 and the land file of Hotian Exhibit 6 are related to OP or not. In Exhibit 1, voter 96, two names are recorded as Bipin Ramdas, son of Surjaram Das, age 46 years, and Monobala Das, wife Bipin Ramdas, age 29 years. OP in his cross-examination said that his name for the first time enlisted the voter list 1990, but he has not submitted the said voter list. OP also in his written evidence stated that his present age is 72 years, that is, he was born in the year 1947. If OP was born in the year 1947, then he was 23 years old in the year 1970. And accordingly, OP's name should be enlisted in the voter list of 1970 along with his parent, but OP failed to explain why his name for the first time enlisted in the voter list of 1990 or 97. Exhibit 2, OP also said in his cross-examination that his father died in the year 1974 and mother in the year 1986. Moreover, if OP was born in the year 1947, then he was 19 years old in the year 1926. That is, OP is younger than his projected mother, only 10 years. Though OP submitted one photocopy of the land deed dated 7/2/1975 by Teresa Ford, but here OP's father name is recorded as Bipindra Krishna Das. Evidence of the PW2, OPW2 is not believable without any document. OP also failed to produce any documents in his name prior to 1971 and also failed to produce related witness of Exhibit 6. So how it be? I have not even produced the related witness of Exhibit 6 and 1. They died. The surprise was the finding. And OPW2 stated, we have seen from the year prior to 96, that OPW2 is the age about a person of 85 years at the time of evidence. And my only discuss only two exhibited documents, 1 and 6. Other discarded. That is not sustainable knowledge. And the documents I exhibited, other sides are not challenged, not objected also. And clause is very much clear also. In this regard, your lordships, non-considered exhibited documents, lordships, judgment passed in the case of lordships. My WS is at page lordships. WS is page 3030 lordships. Yellow. That was.
Yes, Mr. Bagmia.
Yes, WS is paid at 30 lordship. Regarding why not earlier attained, as I stated that when I attained majority, my name was included in the subsequent brutal list. May I read, lordship, that I am not a foreign, I am citizen of India. The name of my father is late Bipin Ram Das, son of late Subjaram Das. The name of my mother is late Monobala Das. My parents were also citizens of India, but serial number so South Korean Constitution, part so for the year 1960. Exhibit 1 is a certified copy of the said brutal list. Since I was minor at that time, my name was not entered in the said brutal list of 1960. When I attained majority, my name was included in the subsequent brutal list, brutal list. But I produced on the brutal 97, but my name appeared in the subsequent brutal list. Exhibit 2 is the brutal list of 4 South Korean LSC for the year 97, in which my name finds place as so-and-so, my wife's name and my daughter's name find place in that brutal list as the brutal's number so-and-so, so-and-so. Exhibit 3 is the brutal list of said constituency for the year 2005. Names of myself, my wife, my 2 daughters, and 2 sons finds place as brutal's serial numbers so-and-so, so-and-so respectively in that brutal's list. My name has been included in the brutal list of the said constituency part so-and-so for the year 2011 as brutal number so-and-so by Xerox copy of the brutal list slip exit report issued to me by the government to show that I had and have a house at village Vasudev Nagar under Dalchara Gaon Panchayat police station for the country. I submitted original house tax receipt number so dated 27/2003, exhibit 5, granted by the authorized officer of the said Gaon Panchayat to show that I have landed property in my name in the said village Vasudev Nagar. I submitted Xerox copy of the registered Kabbalah number so dated 2/7/1985, exhibited by Sunilal Das in my favor. I marked this Xerox copy of the registered Kabbalah as exhibit 6. The instant case is fit to be decided in my favor. Then I also additional WS also submitted lawsuits. Page 38 that is. And first WS it was cross examined also page 35. Page 35 is the cross.
Yes.
Cross by the state, page 35 lawsuit. I was born at village Bilbari, Vasudev Nagar. I have not submitted birth certificate and school certificate. My father's name is late Bipin Ramdas and grandfather's name is late Suraj Ramdas, all expired at village Vasudev Nagar. My father expired in the year 1974. My mother died in the year 1986. My brother's name is Vijay Das. My sister's names are Savita Rani Das, Sairani Das, and Sumitra Das. All are still alive. I have not submitted land documents prior to 1970. My uncle's name is Devendra Das, who died at Bilbari, Vasudev Nagar, about 20-25 years ago. Late Noimal Das is the son of Devendra Das. My name for the first time listed in the brutal list 1990. I have not submitted a copy of the brutal list in my name of 1990. It is not a fact that all documents submitted by me are not related to me and collected documents. It is not a fact that I am not a foreigner. That is the philosophy. There is no challenge at all. Not denied that I am not the son of so person. That I am not resident of so. Even there's no suggestion whether the petitioner is a foreigner or citizen of India. Admitted. My evidence documents, all admitted documents. And evidence of GW2 lordship will also find my additional evidence is page 38.
Yes.
Page 38 lordship, additional examination in chief. Second paragraph, Lordships, that on 15th February 2019, I have submitted my examination chief on affidavit in the above mentioned case. Through oversight at the time of submission of my said examination chief of affidavit, I have not submitted voter identity card issued by the Election Commission of India in my name and final Kotian published in the name of my father, Exhibit 5, proved in original, is photostat copy of voter list ID number so in my name, that is Binoy Das, son of Bipin Ram Das, for the Assembly Constituency, Port Karimganj South, village so Karimganj, district Karimganj, part so. The village Basudab Nagar was under Moja Sotkorabul. My father Bipin Ram Das, son of late Surjaram Das, alias Bipin Chandra Das, son of late Surjaram Das, was a Juddar under the Jamindar Suraj Bihari Dev Purakasto in respect of the land of old dark number so, Moja so, Paragana so, police station, Patakandi under the Kachar district, now district Karimganj. The government of Assam by government notification number so dated 2096 acquired the jamindaris of the then Karimganj subdivision of Kachar district, now Karimganj district. Accordingly, at the time of first settlement survey, my father was found in possession and exhibit 6 in the final Kotian number 3 of Moja Sotkoragul, Paragana so, police station Padagandi was published in the name of my father. The statements made above are true to my knowledge and belief. Then cross part page 40, Lordship. Second paragraph. My name is Binoy Das, son of Bipin Ram Das, village so. The profession dependent on oath, crossed by the state judicial agency. Exhibit 6, the final Kotian in the name of my father. Some part of the land is sold by me. It is not a fact that Exhibit 6 is not related to me. That Exhibit 6, Lordship will find is page 14. Where father was a Jugda under Jamindar of Lordships, will find Suraj Bihari Deva Purakasto. In page 14, Lordships, immediate Kotian numbers also details portion. That in the bottom, Lordship, in the right acquired government under state acquisition Jamindar Jack also amended up to the government notice number 103964. Then Kotian number, owner's details of portion. C. Bipin Chandra Das, my father, son of late Surjaram Das, certified under Social ST Act number amended up to date. This recorded of right has been finally published under 109 of the same Act on 28th of 1967. And DW2, Lordship, OPW2, page 42. And listen, brutally discarded, stated that he has not produced any document, but he produced a document, voter ID card of his name, Lordship. With the tribunal, without applying an independent mind, stated that no documents he produced. Just his evidence is page 42, Lordship, fine. And he has also not been cross-examined also. Page 42, second paragraph, that I am a citizen of India, Exhibit 7, proved in original, is the xerox copy of my voter's ID, issued by the Election Commission for the Assembly Constituency, Fort Karimganj South, village Basudev Nagar, PS Patakandi subdivision, Karimganj, district Karimganj, Assam, Patwa Sonso school. Myself and C. Binoy Das was our residents of the same village. Binoy Das is the petitioner, Lordship, village Basudev Nagar. We are known to each other since our childhood. Late Bipin Ram Das, father of Binoy Das, and late Monobala Das, mother of Binoy Das, were also residents of village Basudev Nagar. And they are also known to me since prior to the year 1966. Said Bipin Ram Das and Monobala Das, prior to their death, have been residing in the same Vasudevnagar continuously and uninterruptedly since prior to the year 1966. Said Vinod Das is also have been residing in the village Vasudevnagar continuously and uninterruptedly since prior to the year 1966. With the knowledge of all, said Vinod Das is a citizen of India by birth and he is not a foreigner. The statement made above are true to my knowledge and belief. I swear this also. But no cross I find losses in the but tribunal totally discarded his evidence as a man of age.
Cross-examination is there. He was cross-examined on 25/4/2019.
Oh, loss, I'm sorry, my judgment also not reflected on that also. Totally discarded. So I also did not find that this cross examination lawsuit. And lawsuits only tribunal discarded the exhibit 1 and 6. Other totally discarded. My evidence also. Only statement, no considerations at all. In this regard, I have relied upon the decisions of a lordship judgment in WBC number 8243 of 2018 regarding non-consideration of the oral evidence and documents.
8243 of
WBC number 8243 of 2018, Jamila Khatun versus Union of India. And another decision losses 2024 GLT 611 2024 GLT 611 Farida Khatun versus Union of India. Double this one. Plus a paragraph 456. Jamila Khatun paragraph 4, 5 and 6. May I read? 4 paragraph 4 losses page third page inner page losses. On receipt of a notice appearance, the petitioner submitted her written statement on 7/4/2017 along with 13 documents denying that she is a foreigner and claimed that her parents are late Azmat Ali and late Moharjan and that she was born in village Wardap under 60 number Kondabar so-and-so Gapancha in the district of Nalbari. The petitioner also projected that the name of her parents were enlisted in the voter list of 1966 and 70 in the village Siduni under Jonia LSE. In support of her stand, the petitioner had examined 4 witnesses, which herself as DW1, and had exhibited 13 documents to Johiruddin as DW2, Kamaluddin as DW2, Sultan Mahmud as DW4, Kartik Kulta as DW5, Ratish Ramchari as DW6. However, in paragraph 4 of the impugned opinion, the learned tribunal has mentioned that petitioner has adduced the evidence of 5 witnesses, impugning herself and exhibited 13 documents, and in paragraph 8 of the impugned opinion, all the 13 documents are referred to. However, in paragraph 10 of the said opinion under the heading Decision and Reasons thereof, the learned tribunal has briefly discussed only the evidence of DW2 and DW4 and has referred only to the certificate issued by the Secretary 60 number Kandahari, Dagapada, Gapanchai, Exit 1 and Bhutan list 1989, Exit 7. Thus, the learned member Foreigners Tribunal number 2 Nalbari has failed to discuss the evidence of DW1, DW3, DW5 and DW6 and the said learned tribunal has also failed to discuss the exhibits 2 to 6 and 8 to 13. Under the circumstances, the court is the unhesitant view that a learned tribunal has not properly appreciated the documents and evidence adduced by the petitioner and as such, the impugned opinion dated so-and-so is held to be not sustainable on facts and in law. Therefore, the said impugned opinion dated so-and-so passed by the learned member Foreigners Tribunal so-and-so in case number so-and-so is hereby set aside and direct the matter to be remanded back to the said learned tribunal, which will be required to reappreciate the evidence and give a fresh opinion in accordance with law. Next, I will rely upon the decisions of this court lawsuit 2024 GLT, page 611, Farida Khatun In that case, Lordship, paragraph 9, 10, 11, and 12. So that in paragraph 9, Lordship. Lordship, what is second one? Paragraph 9. The reference to a tribunal by the SQ border is in respect to the status of citizenship of the petitioner as to whether she is an illegal migrant entering India after 25 to 1971. According to the facts in issue before the tribunal, whether the petitioner is an Indian citizen and whether she had been able to establish a citizenship prior to 25 to 1971, the term facts in issue is interpreted under Section 3 of the Indian Evidence Act 1872, which is reproduced here below. Facts in issue, the expression facts in issue means and includes any fact.
Mr. Sharma, SB 3, 4, 5, 6, not discussed, 3, 4, and 5, and 7, not even discussed. There's nothing relevant to it, but it has to perform its duty in accordance with law. This one's in page 46, while saying what the evidence is, but in discussion, there's nothing.
Just mention exhibit 3, 12.
It is in the narration, but in the discussion, it's not there. It has to go back. Okay. But, if you were here and counsel for the petitioner and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so-and-so, as I said, the opinion dated page 45. Dated 10/5/2019, passed by so-and-so in FT case number so-and-so, IMDT reference number so-and-so, old case number so-and-so, which the petitioner was declared to be a foreigner of 4/28 in 1971 state. Next. In view of the nature of order which is proposed to be passed, the entire facts and evidence has not been referred to. Stop. Next, it was suffice to mention that apart from filing the written statement, the petitioner had examined himself as DW1 and along with his evidence on affidavit, the petitioner had exhibited the following documents. Certified copy of voters list of 1966 within bracket exhibit 1, showing the names of two voters as Bipin Ram Das, son of Surja, Surja, Surja Ram Das, and Manobala Das, wife of Bipin Ram Das. Same comment. Certified copy of voters list of 1997. Showing the name of Binoy Das, son of Bipin Ram Das, and Sita Rani Das, wife of Binoy Das. This is exhibit 2. Exhibit 2 showing the name of so-and-so. Petitioner had also exhibited exhibit, semicolon, then voters list of 2005, within bracket exhibit 3. Disclosing the name of 5 voters, including Binoy Das, son of Bipin Ram Das. on the receipt dated 27/1/2003, issued by the Dhalchera, DHALCHERRA, Dhalchera Gaon Panchayat, within bracket Exhibit 4. Ethic of the petitioner within bracket Exhibit 5. Certificate copy of final Khatian within bracket Exhibit 6. Full stop. Next one, the petitioner had also examined. The petitioner had also filed an additional evidence on affidavit. Next one, he was cross-examined by the state earlier on 15/2/2019 on, and he was again cross-examined on the additional evidence on affidavit on 25/4/2019. He had also examined one Binoy Das. Sorry, not Binoy Das. It's Satyendra Kumar Das, SATYENDRA, Satyendra Kumar Das, KR Das, KR, stop Das, as DW2. Claims to know the petitioner since his childhood and is a resident of the same village, and he had exhibited his epic as Exhibit 7. Full stop. He was cross-examined on 25/4/2018. Next one. In the impugned opinion, although the 7 exhibits have been referred to, but during discussion, what the discussion and appreciation of the evidence was restricted to Exhibit 1 and 6. And there is no finding by the said learned tribunal on exhibit numbers 1 to 5 and 7. Moreover, exhibit number 1 and 7 were discarded. With the finding that they are not related to the petitioner, and the evidence of PW2 was discarded, being not believable without any document. Stop. Resultantly, the petitioner was declared to be a foreigner post 25/3/1971. Next one. As the learned tribunal has not discussed exhibit numbers 2 to 5 and 7, the court is of the considered opinion that this calls for a remand of the matter back to the said learned tribunal for a fresh appreciation of the evidence on record. Next is court in exercise of statutory jurisdiction not venture to examine and deal with the exhibit numbers 2 to 5 and 7, as this court is not exercising any appellate or revisional jurisdiction. And in exercise of statutory jurisdiction, original documents cannot be examined so as to make this a court of make this court to act like a tribunal to appreciate the original documents, exhibited documents. Next up. Accordingly, the writ petition stands partly allowed to the extent as indicated above, subject to following orders. Next, number 1. The matter is remanded back to the learned Foreigners Tribunal, Roman 2, Karimganj, for a fresh decision after, for a fresh opinion after discussing all the exhibited documents. Next, the petitioner, who is duly represented by his learned counsel, is directed to appear before the said learned tribunal on or before 29/4/2026, and by producing a certified copy of the order from wait for further orders that may be passed by the said learned tribunal. Next is make clear that if the petitioner does not appear before the said learned tribunal, on the date fixed, said learned tribunal shall have the liberty to treat the petitioner as absent from call and pass such orders as may be deemed fit and proper. Next paragraph. Not with the main paragraph, 1 to 3, main paragraph. The registry should send back the records. Expeditions of the said learned tribunal. Next, according the writ petition is allowed by interfering with the opinion dated impugned opinion dated 10/5/2019 on terms as indicated above. Next, the parties are left to pay their own costs.
Obliged.
Item 4 or motion.
And take back your citations. This is yes, Mr. Ahmed.
After
adjournment?
21st.
Both sides are represented on the prayer made by Mr. A.M. Ahmed and counsel for the petitioner. Rest has adjourned today. This story.
The 22nd. publish.
Item 5 for motion.
I want some time because I want to go through the trial court record.
After some time, okay.
So can it be in the next week?
What was that? On the prayer made by Egan is wrong.
Just I can go through the record.
7th of March.
Okay. What do we have it?
Item 6. WBC 4577/19.
May it please your lordship. Lordship, in this case, lordship petitioner declare foreigner, the post of 71 lordship. Informed opinion is page 68, my lord. Page 68, my lord, my lord, the last page, in page 73, on the basis of petitioner declare foreigner, and page 73, second paragraph. My lord, most importantly, it is observed that OP has never mentioned his mother's name in his WS and his evidence. From this point of view, also OP's relationship with his projected father, Harendra Mohan Burman of voter list of 1965 and 1970 cannot be enlisted. But we have mentioned in our evidence, madam, mother name is, madam, evidence portions. Page 45. Paragraph number 1. That the second party born and brought up at the village Bhalavita under Bopra Road Police Station. Father's name is Harendra Mohan Burman, alias Haren Burman, i.e. Harendra Mohan Burman, alias Haren Burman is the same and one person. And my mother's name is Jardabala Burman, madam. We have mentioned in the evidence also, madam, my mother's name. So submitted of the voter list from 1965 to up to date voter list, madam, submitted my father, mother, and my Petitioner also.
Yes.
My lord, finally come to the page 20, voter list of 1965. The name of the fathers of the petitioner and mother, my lord. That is the exhibit A, my lord. Harendra Mohan Burman is the father, Jarodabala Burman is my mother, my lord. Village is Balabita, my lord. Voter list of 1965 with exhibit A, my lord. Page 20. Page number 20, my lord, the Bhutta list of 1965. My lord, Harendra Mohan Burman is the father and Jarajawala Burman is the mother, my lord. 1965. Then, my lord, page 22, Bhutta list of 1970. The name of the father of the petitioner, Harendra Mohan Burman, and my lord, Jarodawala Burman, my lord. Josodawala Burman. Jaroda. Josodawala Burman. And my lord, in the Bhutta list of 1968, Jarodawala Burman. Josoda and Jaroda. Josoda and Jaroda. Bhutta list of 1965, my mother name is Jaroda Bala Burman. And Bhutta list of 1960, Joshuda Bala Burman. Jaroda and Joshuda mother. Yes, my lord. This is the only reason for discarding the name, but London Tribunal has said you have not mentioned my mother names, my lord. But we mentioned in mother name, my lord, in evidence, my lord. Jaroda Bala Burman. No. My lord, yes. Yes, yes. Mandela? No. Either. There is either.
2-3 days after. 25 marks.
25 marks. Obliged, Your Honor.
Item 7.
May I please, Your Honor?
Yes.
Lordship, here in this case, Lordship, the procedure was declared as a foreigners by an ex-parte order, Lordship. Actually, two ex-parte order, on the same procedure. First was in passed on Lordship 21/10/2017, page 19, Lordship. Page 19 onwards. Yes, Lordship. Page 19, Lordship. The ex-parte order, Lordship, passed on 21/10/2017, Lordship. Married, Lordship. This is reference case made under Rule 2(1) of the Foreigners Tribunal Order 1964 by the Superintendent of Police Border Competent Authority, District Kachar, Silchar, Assam, for opinion whether the proceeding OP, Pratibha Vala Das and others is there or are not foreigners within the meaning of Foreigners Act 1946, the stream of the foreigners coming into the Assam on or after 25/3/1971 under Section 6A of the Citizenship Amendment Act. The reference case so received is registered as FT 90, FT 4th 92 2015. On my court, notice is issued including the name of the others as per here and served upon the proceedee OP. OP's husband received the notice. Petition filed on behalf of the OP praying for time which is allowed. Thereafter, none appeared. Neither OP did not appear, nor anybody on behalf of OP filed objection as to notice, nor filed WS and evidence. Ex-parte proceeding is drawn against the OP, SIB category of PS being authorized by SPB border. Kachar is examined as PW1 state witness who proved the reference case Exhibit 1 against OPs. Exhibit 2, the service of notice upon OP. The reference case is that OP illegally entered India, Assam through unauthorized route without any valid document on or after 25/3/1971. From this contrary, the original Bangladesh village Khatakal, PS Itna, district Moimunsingia, address OP is foreigners of post 25/3/1971. In reference forwarded by the Superintendent of Police B, referral authority, the name Srimod Das, husband, Mohanlal Das, son, and Noyantara Das, daughter of OP are also recorded. As per here, OP entered India illegally after 25/3/1971 with family members. Place of birth of the OP and family members, Bangladesh. Now, as per Section 9 of the Foreigners Act 1946, the owner's burden of proof that proceeding OP is not a foreigner lies upon OP, notwithstanding anything contained in the Indian Evidence Act 1972 without submitting any objection as to notice. WS evidence OP filed to discharge his burden of proof in spite of having ample opportunity. As per Section 314 Foreigners Tribunal Order 1964, reference case is to be disposed of within a period of 60 days. The state submitted the ground of which the claim of the proceeding OP is to be foreigners. Peruse the CR considering all the material available on record on hearing, the state and the case being proved that OP is foreigners of post 25/7/1971. I am of the opinion that OP is Pratibha Vala Das, Srimad Das, Mohanlal Das, son and Noyantara Das daughters are foreigners of post 25/3/1971. The judgment of fine is expressed ex-parte on this day of 20/10/2017, declaring Srimati Pratibha Vala Das, Srimad Das, Mohanlal Das, and Noyantara Das are treated as foreigners. Reference answer affirmative in favor of the state. Rest of the part at the direction. Now, Lordship, in another judgment, Lordship, is at page 24 onwards, Lordship. This is also ex-parte against the same proceeding. Two simultaneous proceeding on the same tribunal was continued. Page 24, Lordship. Type copy, Lordship. OP is absent, heard the argument, learned AGP for the state. Reference against OP and family members is that they entered into India after 25/3/1971 in search of work illegal through unauthorized route in their country of origin, Bangladesh, that is Katakhal, such and such, and illegally stayed in India. Srimad Pratibala Das, wife, Mohanlal Das, son, and Nayantra Das, daughters, are also from Bangladesh, and their place of birth is Bangladesh as recorded in CR, hence foreigners. Reference is registered being FT 4th 93-2025, notice issued to the OP and family members as per CR. Notice is served, notice is received by OP Proceedings Srimad Das as per notice of police border. OP did not appear nor file any WS evidence, rather remain absent in different date fixed. As per section 314 of Foreigners Tribunal Order 1964, the reference is to be disposed within a period of 60 days on receipt of the notice reference from competent authority. Heart State ex-parte proceeding drawn against OPSI B category PS is examined as the state witness. As per section 9 of the Foreigners Act, the burden of proof lies on the OP. The proceeding is not a foreigner. Without submitting any WS evidence, OP failed to discharge their burden of proof as per requirement of section 9 of the Foreigners Act. Considering the entire material on record, I am of the opinion that OP Proceedings Srimad Das, his wife Pratibala Das, son Mohanlal Das, daughter Nayantra Das are foreigners of post 25/7/1971. Reference is allowed affirmative upon all concerned. Now, Lordship came to notice was issued in FP 4th 2016, Lordship. Page 9 onwards, Lordship. Here, Lordship, only notice has been served to the petitioner number 1. That is the husband of the petitioner number 2 and father of petitioner number 3 and 4. No individual notice has not been issued against every individual. And similarly, Lordship, in page 12, Lordship will find in case number FT 93, 2015, Lordship, as per service report from the server, Lordship, type copy is page 14. He could not found the proceedee by name, and thereafter, Lordship, I am reading the operative part. After going to the address mentioned in the notice address, could not be found that there by that name. After searching the area and after asking the elderly persons on that area, I could be known that no person by such name resides there. As a result, notice could not be served. After obtaining signature of the local witness, the notice is returned. So in 93, no one get any notice, Lordship. They only came to know about this proceeding on the proceeding while the NRC proceeding was initiated, Lordship. Now, Lordship, the petitioner number 1 father, he was registered as a citizen, Lordship. Citizenship registration card is page 29. (1970), Lordship. Issued by the registration of citizen, Lordship. Is dated 15/2/1971. 15/2, Lordship. Name is Ramlal Das, who is the father of the petitioner number 1. Page 30 is the vernacular, Lordship. And his name also recorded in the 1970 voter list, Lordship, along with his father, Ramlal Das, Lordship. Yes, Lord. So as per the registration authority, Lordship, the citizenship issued to the father of the petitioner number one, Sri Ramlal Das, Lordship, is at page 30, Lordship. That copy is page 29. He was conferred citizenship on 15/2/1971, Lordship. And page 32, Lordship, 1970, voter list, Lordship. Ramdas Lal name was there, Lordship, along with Lordship Srimad Das, the petitioner number one, who is the father of the petition number 3 and 4, Lordship. And also, Lordship, in petition, admission registered of new migrant camps, Lordship, in case of Lordship petitioner number 2, was the wife of the petitioner number 1, Lordship, and mother of the petitioner number 3 and 4. Also in the year, Lordship, 1964, they were in migrant camps, Lordship, at Damsora. Copy is annexed as page 33 and 34, Lordship. So these records prove that they are the proper Indian citizenship, Lordship, petition number 1 and 2, and 3 and 4 are citizenship by citizen by birth, Lordship. The interim judgment was passed ex-parte, Lordship, as because the notice has not been served properly to the petitioners, Lordship. If notice could have served properly, then they could have appeared and
Not only notice was served, but you also appeared and took adjournments.
only petitioner number 1, Lord.
That we don't know. In both the cases, there are petitions
Yes, Lord.
seeking adjournment.
So one opportunity may be given to appear.
Because then your writ petition is based on false statement. If you have a registration certificate
Lordship.
and you are the person, then you have to move the government.
Registration is in the name of petition number 1, Father, Lordship, Ramlam Das, Lordship.
It is not your case that your husband was a minor at the time when notice was served on him. You are saying that notice, you are not saying that notice is not served. You are saying notice, valid notice is not served.
Lordship. Yes, no separate notice, Your Lordship.
That is a defect in form, but this notice is received by Srimad Das. Srimad Das is
Yes.
your husband.
Yes,
Your husband does not suffer any disability. He was not minor at that time. So how the notice is not properly served, not validly served? If it's received by your husband, covered by P5F, if it would have moved the tribunal for sitting aside of the ex-parte that you did file an application. Mr. Sharma, setting the records. Mr. Sharma, there are 4 records here. First record you omit, just take the file, just omit that. First record you omit. Is the second record. No, the entire set. Remove the entire first set. There are 4 records here. Remove the first record. Go to the second record. No, Mr. Sharma, that is not how you look at the records. We told you there are 4 records. Remove the first record. This is not how you see the records. Yes. Number 2, this is the miss case.
Yes, Lord.
Now see the order sheet. Miss case for setting aside. Next page, turn over next page. Order sheet, yes. Now this was proceeding and then dismissed for default. Next page again. Dismissed. Now remove the second record and remove the third record. Remove the third record. Again a miss case. This is by that Pratibha Wala Das. Again, this is dismissed for default. Look at the order sheet. Dismissed. End of your matter. Your miscase for setting aside was dismissed. Yes, that against that there is no challenge. So the dismissal would stand. Your dismissal has to be dismissed.
So probably this fact was not communicated to the earlier council lordship.
There you were, it was there very well there. You could have gone through the records. You find that the looking of the trial court records is something which is very, what do you call it? It's manual work. Look at the records. You are a high court lawyer.
Okay.
We are both from trial court, so we don't have any misgivings in looking at the record. We have seen the records. You don't.
Lordship,
You are class apart than us.
Lordship, I apologize for that, Lord.
It's not a question of apology. You're cutting a sorry figure. Every day we say, look at the records. Since you don't look, we have stopped giving the record. You still don't look. Problem is that if you are dealing with a trial court record and you don't know how to look at it, it hurts your ego to look at the trial court records.
No, no,
It's meant
not
for
like
small lawyers,
no, Lordship. Definitely.
and we two are the small people here.
not.
We don't mind looking at the LCR. Sorry, we'll have to dismiss it.
Lordship, I may be allowed to file an amended petition, Lordship.
You can't do it. Do not check the records, it's your problem.
One opportunity, Lordship.
You can't give it. You can't give it. This is encouraging, what you call, it be encouraging the lawyers not to look at the record. When we catch it, then you say that we don't know. When we had an opportunity, you don't see. Your name?
P.A. Chaudhary.
P.
A. Chaudhary.
P.S.
P.A. Chaudhary.
P.A. Chaudhary, counsel for the petitioner, and Spencer for the respondents. Next one, by filing this writ petition under Article 226 of the Constitution of India, we'll take a short break and come back.
It's 24.
Page number 24. Passed, dated 7/8/2018, passed by so and so in case number so and so. By which the so that in the first case you will say 4th of 92, that is page 19. That is against Pratibha Bala Das, petitioner number 2. And second opinion at page 24. It's all the petitioners. Petitioners number 1 to 4 declared to be foreigners of post 25 May 1971. So for both the opinions were passed ex parte. Next one. The learned counsel for the petitioner has submitted that the common notice was issued in both separately in both the proceedings. And while notice in case number 4th, FT 4th oblique 92 oblique 2015, the name of the proceedings were number 1, Pratibha, P-R-A-T-I-B-A, Pratibha Bala Das, number 2, Srimad S-R-I-M-O-T Das, number 3, Mohan Lal Das, and number 4, Nayantara Das. The notice in the second proceedings being FT 4th 93 of 2015. The names of the proceedings were Srimad S-R-I-M-O-T-H, Srimad Das, Pratibha Mala Das, Mohan Lal Das, and Nayantara Das. Accordingly, it is something that those were not valid notices, not separately issued to all the proceedings, and therefore defective. It is further submitted that the petitioners had no knowledge of the ex-parte opinion, and they came to know about the opinion only during the proceedings of the National Register of Citizens, in bracket NRC for short, and accordingly by obtaining certified copies. 7/5/2019, the present declaration has been filed. Send the said two ex-parte opinion. So it is further submitted that the father of the petitioner number 1, namely Srimad Das, had been issued a citizenship certificate dated 15/2/1971 by way of registration of his name by the special officer for registration of citizens, future, dated 15/2/1971. And the name of Pratibha Das, Pratibha Bala Das, the petitioner number 2 was also entered in the admission register of new migrants. Showing their camp roll number between the period from 1/10/1964 to 24/10/1964. Under serial number 1 347. Accordingly, committee that an opportunity be given to the petitioners to find their written statement and address the proceedings. Next paragraph. For contract, the learned Canipus for the FP matters has made his submissions in support of the opinion. Next paragraph. Just give the record. Upon perusal of the tribunal's records of both the proceedings, i.e. case number FT4/93 of 2015 and FT4/92 of 2015, it seemed that the process that was issued on 22/7/2016 was duly served on Srimad Das, the petitioner number 1 in this particular. Appearing on behalf of the petitioners, his learned counsel, the counsel for the petitioner number 1 had filed his wakalatnama. It was accepted on 24/1/2017. Available on record are 4 adjournment petitions filed on 18/12/2016, 28/12/2016, 24/1/2017, and 2/6/2017. As per the tribal record, the petitioner was absent without script on 10/8/2017, 24/8/2017, 28/10/2017, 6/12/2017, and 7/3/2018. Accordingly, on 6/2/2017, the British of the state was examined and the reference was marked as Exhibit 1. The service of notice, this is a process service report, and the process were marked as Exhibit 2.1 and Exhibit 2, 2.1 and 2.2 respectively. The signatures of the process serving police personnel were marked as Exhibit 2, 3 and 2.4 respectively. Accordingly, the matter was fixed for ex-parte opinion on 7th May 2018. Accordingly, the ex-parte opinion was cleared on 7th May 2018. Stop. Next, also available on record. Is the record of FT miss case number 40 of 2018. Was filed in connection with FT fourth case number 93 of 2015. They said the application was under section 3 capital A of the Foreigners within bracket Tribunals bracket was order from 1964 for setting aside the ex-parte opinion dated 7th May 2018. Such application being made from the Learned Tribunal by order dated 5/9/2018 granted bail to the petitioner Srimad Das within bracket petitioner number 1. However, to the order sheet. However, as per the order sheet, on 22/10/2018, petitioner number 1 was present. On 28/11/2018, the petitioner filed petitioner number 1 had filed his Alia, but his advocate did not turn up for hearing. On 18/1/2019, the petitioner was absent without steps. And again on 1/3/2019, as the petitioner was absent without steps, he said miss case number 40 of 2018 was expenses. Next. Coming to the record of FT4 of the 192 of 2015. Process right. Process of the notice right. Notice dated 27/6/2016 was duly served on the petitioner number 1 or the adult member of the family, or did receive notice addressed to Pratibha Varadas or Srimad Das, Gopal, no, Sri Mohanlal Das, and number 4, Nayantara Das. Therefore, notice is found to be duly served on the adult member of the family. As per record, the petitioner number 1 Learned Council filed a petition for adjournment on 9/9/2016, 31/10/2016, 8/12/2016, 28/12/2016, 24/1/2017 and 1/6/2017 as per the order sheet. The petitioner was absent with steps on 28/12/2016, 24/1/2017. However, on 24/1/2017, no, sorry, 10/3/2017, 1/6/2017, 25/8/2017, Twenty-two 9/2017, petitioner remained absent. Accordingly, on 22/9/2017, the PW1 was examined on behalf of the state. And the matter was pitched for an offer of opinion on 21/10/2016. Records, next penalty records also reveal that in order to set aside the said ex-parte opinion dated 22/9/2017, the petitioner number 2, Pratibha Baradas, filed this case number 37/2018, arising out of FT4, case number FT4/92/2015. On 4/9/2018, the petitioner number 2, Pratibha Baradas, was granted bail, and she was present before the tribunal on 22/10/2018. On 28/11/2018, attendance was filed on behalf of the petitioner, but none appeared for hearing. The petitioner remained absent without steps on 10/1/2019, as well as on 1/3/2019. Resultant, he said this case number 37/2018 was dismissed by order dated 1/3/2019. Next. This stage, the learned counsel for the petitioner submitted that he was not aware of the filing of the said two missed cases. The missed case number 40/2018 and missed case number 37/2018. Therefore, he paid for some time to file an additional affidavit. Next. Disregard the court's reconsidered opinion that as petitioners had filed application under section 3A of the Foreign Tribunals Regulatory Order of 1954. Both the said missed cases referred above were dismissed. the dismissal orders of the said this case number 40 of 2018 and this case number 37 of 2018 by order dated 1/3/2019 passed in both the proceedings. Having not been challenged from those orders, have attained final. In this case, and incident is issued as there is a in view of the fact that in case number FT 4/92/2015, page 19, for the opinion was rendered on 21/10/2017. The said opinion implicates Srimad Das, Mohan, sorry, Pratibha Baladas, EIDA, Pratibha Baladas, Srimad Das, her husband, and Mohanlal Das, son, and Nayantara Das, daughter, were held to be foreigners. In the subsequent opinion dated 7/3/2018, passed by the same tribunal in FT 4th, in case number FT 4/93/2015, Simar Das, in bracket petitioner number 1, wife, his wife Pratibha Das, in bracket respond number 2, our son Mohan Lal Das, within bracket petitioner number 3, and daughter Nayantara Das, within bracket petitioner number 4, held to be foreigners. This comma, as it is no longer res indica, RESINTEGRA, res indica, that principles of res judicata applies in the cases of foreigners tribunals. The court is of the considered opinion that, notwithstanding that the opinion dated 7/3/2018 passed in case number FT 4th 93 of 2015 is retained finality, but owing to the principles of application of res judicata in the proceedings, only the opinion dated 21/10/2017 passed by the learned member of Foreigners Tribunal 4, Silchar, in case number FT 4th 92 of 2015 shall prevail. Next, accordingly, as the petitioner has accepted the order dated 1/3/2019, passed by the said learned tribunal in this case number 40 of 2018, arises out of case number FT 493 of 2015. No interference is warranted against the opinion impugned in this writ petition. Accordingly, this writ petition stands dismissed. Next, it is clarified that the opinion which would stand against the petitioners is the first opinion dated 21/10/2017, page 19, passed by so and so and so and so. The subsequent opinion dated 17/2018, passed by so and so and so and so, against the court petitioners hearing. In order to remain on record, full stop, however, the same shall not be acted upon. The application of principles of res judicata. Next one. Before parting with the records, Gauhati is submitted that this order shall not cause prejudice to the petitioners in the event the petitioners move the government of India or the state government claiming rights available to the certificate of registration issued by the special officer for registration of citizens, Silchar, dated 15 to 1971, in respect of those who claim those petitioners who claim through Sri Ramlal Das and the certificate of admission register of new migrants camp post 1964 among others. Only in respect of Pratibha Das, the petitioner number 2. Next one, the observations and indicated above of the petitions and dismissed. We are providing two things. Number one, adjudicator applies, so second opinion shall remain, but will not be acted upon. First will prevail. Second is that since if they can show to the government, they can registration and not prejudice them.
File. There was one. If it is not inconvenient, may I request that my matter item 16, maybe take it out too, because there is no time now. Almost 2-3 minutes left. There's some urgency also in the matter.
16. We'll upgrade and take it up.
Man, at 2.
At 2, even though because if we are taking up any matter, that may continue, but we'll take it up.
Item 8 for motion.
Yes.
May I please, Lord? Lord, the impugned opinion, my Lord, is 58, my Lord.
Where is your written statement?
Written statement on page 22.
Yes. Now you will proceed.
Page 22, Lord.
Hmm?
Page 22,
No, we have got it.
Lord.
Now you can proceed as per your
Lord.
preparation.
Impugned order, my Lord, page 58, my Lord. From paragraph 3, my Lord. The proceeding in her written statement stated that she is a bona fide citizen of India by birth. She claims that she was born and brought up at village number 3, Dakshin Rangapani, PS Boko, Mauza, Sontoli, district Kamrup. Her father and mother's name are Kush Bepari and Allah Khatun, residing at village Dakshin Rangapani, PS Boko, Mauza, Sontoli, and married with one Alaruddin at village Romari Pathar, PS Tarawari. She claims that her name appeared in the voter list of 1966 at village Romari Pathar, PS Lorenzo, under 54 number Senga LSE, and in the voter list of 1970, 1989, 1997, and 2016. The Governor of Romari Pathar issued a certificate and admitted that her husband is Alaruddin as well as Aluruddin. After submission of written statement, the proceeding submitted evidence in chief as DW1. Proceeding on 8/11/17, DW2 Hassan Ali on 24/7/18. The Gaur as DW3 produced on 22/11/18. The proceeding as DW1 stated similar facts as stated in the written statement and exhibited some documents as Exhibit A, B, C, D, and E. Voter list of 1966, 1970, 1989, 1997, and 2016. And Exhibit F, Certificate of Gaura. During food question by the tribunal, she stated that There are 4 numbers of sons of her father and 3 numbers of daughters, namely so and so, so and so. She has not disclosed the material facts as such brother, sister, grandfather, brother and sister of her father. The proceeding ought to have disclosed all material facts which are known to her within specific knowledge. Failure to disclose all the material facts, it creates serious adverse inference against the proceeding. Apart from this, the proceeding has not submitted voter list from the side of her father. Exhibit A, Exhibit B, Exhibit C are exhibited from her husband's side. As such, she has totally failed the linkage with her father, Pakku Vyapari of village so and so. She has not mentioned in her statement a single document submitted as linkage with her father, nor regarding landed property. So her evidence is not reliable, sufficient, and trustworthy. In regards of DW2 Hassan Ali, who claims as brother of the proceeding of village plot.
Lord, I'm sorry about mentioning at this hour, item number 49. Is a matter relates to eviction, and today is the last day. And tomorrow we are required to vacate, kindly, if possible, after 2, at any moment. Item number 49, It is a writ appeal, 132 petitioners, appellants are there. If possible, after the break, Fine. Oblige.
We have populated 2 points. First is whether the minutes or resolutions of meeting dated 19/12/2014, 27/4/2015, 19/6/2018, and 27/6/2022 can be said to be a report or recommendation. Here we have held it as no. Incidental point is that if they are not recommendations, would this minutes subsequent to 19/12/2014 be said to be an exercise of review? This also we have held in negative. Accordingly, we hold that the order of the learned single judge is not initiated with for any reason, and therefore this writ appeal is dismissed. It will take some time to upload because it will now go to sister and then her signature will be taken. Please unveil.